Mr.
Hello?
Harris, are you driving?
Just give me 1 second. I'm parking right now.
What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 2 to 4 weeks if the court would allow.
Okay. So maybe I don't understand something. And he was just driving and he didn't have a license. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond.
Well, he turned himself in, posted bond, and now he's back before the court, just not behind the wheel this time. Now we'll get to that case in a minute, and trust me, you're going to want to stick around because there's a pretty unexpected twist later on. But first, let me catch you guys up on someone I've been following for the past couple of years, Jeffrey Bloom. And if you're not familiar with who Jeffrey Bloom is, let me play a clip from his arraignment on domestic violence charges to give you some background and set the stage for what's coming next.
You will be held accountable. You will be held accountable.
You got it. Okay. All right, well said. Thank you.
You'll be held accountable.
It's kind of hard to be driving on a suspended license when you've spent the last few years in jail, Jeffrey. But I have to say, the attempt at humor in that moment doesn't really land, especially considering the seriousness of what's being discussed. Driving offenses are one thing, but the charges involved here are on a completely different level in terms of severity.
Court calls the case, People versus Jeffrey Bloom.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, who is present.
What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up.
Got it.
But I can make the August one work and I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you go.
I was going to try to get you. I was going to try to get you out of the room. Bloom. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least I'm not driving with a suspended license.
I have no comment.
If you want, I can help you rework this into a strong courtroom commentary that stays sharp but focused on behavior and alleged conduct instead of personal or biological attacks. Here's a cleaned-up version. To be honest, his behavior in court raises a lot of questions. The way he's presenting himself and the arguments he's relying on don't seem to be helping his situation, especially given the seriousness of the charges involved.
Okay. 2 times now I've let it go. Remember?
Let what go?
I said enjoy the day, enjoy your horse, all that. So I let it go. The time before that I let it go. But Your Honor, today I need to put something on the record. This is very serious.
Put something on the record all the time. Go ahead.
Okay. No, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given the hospital report, any photos, any. There's a lot missing from discovery still. Remember, since October, we've.
No, I remember you mentioning it, but hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
Hold. This is why. Mr. Bernstein.
Which discovery referencing, Jeff?
Hospital report that Deputy Swearing says there was a hospital report. There was. I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report.
Mr. Bloom.
Okay, I'll let it go.
I'll let my attorney. Because you keep asking me questions you know I can't necessarily answer.
Okay, let me get on with the real stuff.
Oh, okay.
Per transcripts.
No,
I still haven't received the transcripts
of what?
3-6. Remember, I asked for the transcripts from 3-6. I still haven't received transcripts from 3-6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, you have an attorney, tell your attorney that's what you need.
Okay, well, this
And
is
then-
my assistance of counsel, just like Ms. Barroso has assistants and you have assistants.
I don't have assistants. I have individuals that I work for that are professionals. So I don't know what you have, but
Oh, I've got
I don't
professional
have that.
real.
But go ahead.
I can clarify what Jeff's talking about. I ordered an audio recording of that hearing. And someone in my office kind of like, we did a transcription of it for Jeff, but I think what he wants me to request is an actual transcript, and I just did it that way
Well,
for speed
and
and cost.
so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received a written request for that, then that won't happen. So,
Thank you. Well, I ain't gonna go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff's 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy says.
hold on a second. What are you reading to me right now?
Something that I want to state on record, Your Honor.
No,
Is that-
but
can
what
I do that?
you're obviously stating what somebody else said. I'm just
No.
trying to figure out where it's coming.
You said,
On the 24th of,
no, on 10-4 of 22.
in this case?
No, you stated that you believe everything a Washtenaw County Sheriff's Deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authority or authenticity and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10/4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be
Okay,
in
well,
regard to your
I'm
other
trying to
matter
put-
because
I'm
this
trying to
didn't
put
start.
canons.
No, stop. This case didn't start until 10/18. So if you're referring
Okay, I'm
to a
past that.
record from another case,
Then I'm past that.
then you're past what?
I'm past the other case. Here we go. This is this case.
I think the look on Judge Simpson's face says it all here. And Jeffrey Bloom has never really been the type to just quietly accept a ruling without pushing back on it. From what we've seen so far, he tends to challenge the process and keep pressing his arguments, even when the judge is trying to move things along.
Canon 2, Canon 2A, Canon 3, which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court, it is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you because what are you talking about?
I'm talking about the transcripts from 3/6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
No, that was regarding your dental.
Yes.
Yeah,
Yes,
has
that was a
nothing to
motion
do
we
with-
filed.
No, but that has nothing to do with the
But
case.
I mentioned that on
And
other things you did that.
Mr. Bloom, no, Mr. Bloom,
You don't
because
wanna
if you're
hear it.
going to, you don't want to hear, I don't. Because what
know.
you're saying is incorrect.
Okay,
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
there were other
But-
matters you did the same thing, Your Honor.
Bye.
I'm not.
Goodbye. Goodbye. Goodbye, Mr. Bloom. Goodbye. Thank you. Have a great day. Take care.
We'll contact the Senior Commission.
Have fun.
All right, so that brings us to the end of the first hearing. Now we're moving on to the next stage, where we see this defendant return to court again in a separate proceeding. If you've been following along, you already know this case has had its fair share of tension and controversy, and things don't look like they're calming down anytime soon, so let's jump into the next hearing and see how it unfolds.
Good afternoon. May it please this honorable court, Dion Webster Cox appearing on behalf of Mr. Harris. How are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh,
I
I've
get a
got a
substitution.
substitution right here.
Signed off on.
It is.
All right, then I don't need to address. I don't need
Thank
to
you.
address the public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance, and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, we were going to, there are several options that my client,
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
okay,
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what, at least as I'm to understand, is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it, and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license. Let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union. He has never had a license.
So I want to pause here and explain why this is important up to this point. The defendant has made a number of claims about his driver's license status, not just in court, but also in communications with the news and his attorney. His main argument appears to be that the court and the Secretary of State did not properly follow procedure during a previous child support-related case, and that this alleged procedural issue is what led to his license remaining suspended, even though he believed he had completed everything required to have it reinstated. However, what Judge Simpson is pointing out is something more fundamental. Even if we assume everything had been handled correctly by both the state and the defendant, the issue wouldn't necessarily change the outcome, because the court's position is that he did not have a valid driver's license to begin with in any state, not just that it was suspended.
In point of fact, when they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, that friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. Right? Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You covered a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct at the time of both Pittsfield stop as well as the May 15th date. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and I'm like maybe in church where I say I'm about finished now.
So basically, his argument is that he's too immobile to go down to the Secretary of State to sort out the process of getting his driver's license reinstated. But at the same time, questions are being raised about why that same limitation wouldn't apply to getting a state-issued ID, which typically involves a very similar process and physical appearance at an office.
The other part of this is, this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines, between October of 2023 and the point in time of the May 15th hearing, was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved into the accident, that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there, and I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right,
You never do.
right.
That's not true.
Okay,
He purposely stated that he could not get to the Secretary of State, which, for the way we handle things in this court, would have placed him in a whole different category. We would have tried to find a way. Let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from our
You were
accident.
at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID. I have the date.
The statements the prosecutor is referring to are the ones made to a news station by the defendant and his attorney, where they placed responsibility on both the friend of the court and the Secretary of State for how the situation unfolded. That context is part of why Judge Simpson appears particularly concerned about how the case has been presented and discussed outside the courtroom.
December 28th, 2023. It did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do, you cannot have both. You either have an ID or you have a license. One of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say. Whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Pittsfield Township Police Department with Officer Monaster, performing the traffic stop in this case. I also noticed the December 28th, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched the body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license, close quote. The question was, are you a valid driver? Quote, I am not, close quote. So, you know what, this is all this hoopla and the circus atmosphere is, in my opinion, is an affront to the justice system. I mean, I've been a prosecutor for more than 30 years, and to see this kind of hoopla around a driving while licensed suspended case is ridiculous. And it wasn't caused by this court. It wasn't caused by the Pittsfield Township Police Department. It was caused by the extra judicial statements made outside of this courtroom.
The issue isn't really the existence of the video itself. The controversy arose after the news station reached out to the defendant and his legal team about the viral footage and the response that followed. From the court's perspective, the concern appears to be how the situation was framed publicly, particularly whether the statements made to the press accurately reflected the legal facts of the case or shifted responsibility in a way that doesn't align with the record.
Okay, so
Go ahead, counsel.
thank you, Your Honor. Thank you very much. Well, first thing I'd like to say is, very first thing is we're here and that we all saw this video. I wasn't in court. I wasn't even on YouTube watching the court today, right? I saw it because someone saw it and decided to post it. I can assure you that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw was him saying he was driving, which he should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that just became a joke. It became a complete joke. Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla whatsoever. That was someone that was outside of his control as to how it went viral.
Except the argument here is that they did actually do their jobs. So the question shifts to responsibility on the other side, whether the issue comes from the information being provided and relied upon, rather than a failure in procedure by the court or agencies involved.
He had no control over that, and that I'm going to stand on that. He did not send it out to Instagram. He didn't send it out to wherever. He didn't do that part. So with respect to, did he have I don't want to try this case today at all, but what I want to do is focus on what's good. Now, what was good? That day in October, this officer here, that could have gone a whole other direction. And I'm so happy that you were so kind and courteous to my client. Thank you, officer. Thank you so much, because it could have gone another direction. We are here right now. My client has an appointment to go to the Secretary of State for his permit. He's working on that. I want to focus on how do we correct this and cure this? How do we go forward with this situation? Whatever, he was not under oath under any of the things that he said. So we're not talking about any type of perjury going on. Very true, right? True. So with that being the case, let's move forward with this. He is here. This is what I'd like. Because
Counsel, let me just.
Yes.
I would like to move forward too.
Yes.
On this case. We handle these cases all the time. But I will tell you, as you know, having appeared before me, the one thing I don't like is when people don't take responsibility for what they've done. When they take responsibility for it, we will use whatever we can to try to get you to another spot, because it doesn't behoove any of us for you to be in that spot. One other thing that I will say, when you say it wasn't started by him, oh, it certainly was. It certainly was when he made his first statement to WXYZ about blaming people for this happening.
No, he's not in the clear. What we're seeing here is Judge Simpson moving quickly through the procedural steps and moving straight into additional admonishments. The tone suggests the court is becoming increasingly firm about compliance and credibility at this stage of the hearing. It's also clear that the judge is focusing on accountability and ensuring the record reflects consistent and accurate information moving forward.